So let me start with this book first. The book K. Parasaran, Miscellany, Legal Wisdom from Valmiki Ramayana and Retrospective was published in 2024. It is a tribute to the living legend of law, Mr. K. Parasaran, carrying two parts. One, reflections on legal concepts from the Ramayana by Mr. K. Parasaran, and the second portion on reminiscences by eminent personalities drawn from their experiences with the acclaimed Jurist, intended as a scholastic contribution touching on the confluence of ancient and modern law. The book serves as an introduction for all enthusiasts of law and its connection with Indian roots. There is no particular author it is a collective effort brought out by the Shastra University, and I think they deserve a big round of applause for bringing us this unique publication. Now about the hero of the book. Sri Parasaran was born on the 9th of October 1927. He emerged as a venerable figure in the legal field with a career spanning over 7 decades. He was born to Sri Kesava Iyengar, a senior advocate who himself was a renowned lawyer of his time, thus inheriting a legacy of legal prowess. Commencing his professional journey under his father's guidance in the 1940s, he ascended the legal ladder to eventually become one of the top lawyers in India. In the 70s, he served as a standing counsel for Tamil Nadu and later as an advocate general of the state during the president's rule in 1976. His illustrious career further saw him assume the position of Solicitor General of India and subsequently the Attorney General of India from 1983 to 1989, where he was involved in a multitude of crucial constitutional cases. In 2012, he was nominated as a member of the Rajya Sabha. Known for his deep knowledge and understanding of constitutional law, Sri Parasaran earned a reputation as one of India's foremost legal experts and is often called as the Pitama of the Indian bar. He was involved in several landmark cases throughout his career, shaping legal precedents and influencing the course of Indian jurisprudence. Some of the landmark cases wherein he has been involved include the National Judicial Appointment Commission, Bhopal gas tragedy case, the Kaveri River dispute, Hotel Federation case, Sabrimala case, and the Ayodhya case. He has also been nominated as a member of the Working Committee of the Constitution, headed by Justice M.N. Venkatachalaya. His accomplishments are numerous, with accolades such as Padma Bhushan in 2003, Padma Vibhushan in 2011, and more recently he was awarded the Most Eminent Senior Citizen Award from the then Vice President Mr. Venkaiah Naidu on account of his distinguished career. In the recent past, he garnered widespread attention for his pivotal role in the Ayodhya case, further solidifying his reputation as a legal luminary. In 2019, he was also appointed as a member of the Sri Ram Janmabhoomi Tirth Kshetra Trust. Beyond his legal pursuits, Sri Parasaran possessed a deep affinity for the Valmiki Ramayana. Displaying a profound interest in law drama, his passion coupled with his dedication to the legal profession led to the publication of a book by Shastra School of Law. The first section of this book presents the esteemed lawyer's interpretation of law within the Valmiki Ramayana, offering insights into his perspective. The second part comprises a compilation of letters from his contemporaries and other legal luminaries sharing their reflections on Sri Parasaran. May I now invite Mr. Arvind Pandyan, a trustee of the Chennai International Center, to please say a few words and welcome our esteemed guests.
Thank you, Mr. Chandramouli. Honorable Justice Lakshmi Narayanan, Mr. N. Venkatraman, other senior lawyers here, friends, ladies and gentlemen, Mr. Chandramouli, the CEO. On behalf of the Chennai International Center Trust, as one of the trustees, I deem it as a privilege to invite all of you for this wonderful legal, I would only say not just a discussion, but it's going to be elucidation of various facts, both on law as well as also the great Pitamaha, is what we call. Chennai International Center was started sometime in 2015-16 to ensure and celebrate Chennai as such, or what we used to call as Madras. So on the Madras Day at Fort St. George, Mr. Gopal Srinivasan, who is the foremost person to see this vision, he got a few of us to come together and got us to Fort St. George and ensured that that day should be celebrated by forming the Chennai International Center on the same lines as India International Center. And then we had the Pune International Center. We also had the Bangalore International Center. Thereafter, the Chennai International Center has come now. We are at the brink of having our own place very soon. We have been having all talks from artificial intelligence to environment, law, constitution, you name it. Added to that, very many books have been released here. Various books have been debated, presented, and also all the authors also being here. So here you will find my wonderful colleague, Mr. Amrit Bhargav, who's been one of the architects along with the university, headed by none other than our Mr. Vaidya, who's very active also in the Chennai International Center, bringing out this book. And Shastra is no, I would say, surprise to do this for the benefit of the great man. We only call him as man because he's physically here, but otherwise he's virtually God in our profession. Representing him, Mr. Satish Parasaran is here. It's a family not just of lawyers, but just totally eminent jurists. One point I would just like to add about Mr. Parasaran is the family, Mr. Head, Mr. Keshava Engar, was the first designated senior counsel as the Madras High Court when it was given to an Indian as one of 1944. And then came after him Mr. Parasaran naturally, and now the third generation also continuing, Mr. Mohan Parasaran and Satish. Looking forward to the fourth generation, Mr. Rahul Balaji, also to become very soon. So that's the family as such which we know personally, all of us, not just on a personal note alone, but also for the whole profession as such. So today to have this book, I would say, debated and also discussed in the August, I would say, premises of Chennai International Center at this venue also gives us total privilege. So I thank Mr. Chandramouli for having organized this on behalf of the trust as well as the center. I hope all of you will surely have a wonderful time, and at the end, maybe when you ask a few points and during the discussion, you'll get much more idea also about the future events to come. Thank you very much.
Thank you very much. Our eminent panelists who will discuss the book, Honorable Justice V. Lakshmi Narayanan, is an accomplished legal professional with extensive experience in academia, international representation, and practical law. Since 2010, Justice V. Lakshmi Narayanan has served as the Deputy Editor-in-Chief of the prestigious Madras Law Journal and its criminal counterpart, while also contributing as a member of the Honorary Editorial Committee from 2008 to 2010. His editorial prowess extends back to his role as joint editor of the Student Advocate in 1994 and 95, and he continues to influence legal scholarship as a member of the Honorary Board of Editors for the Indian Student Law Review. Justice Lakshmi Narayanan has co-authored notable works including contributions to Halsbury's Law of India on landlord and tenants alongside renowned legal experts such as Mr. K. Kannan and Justice N. Anand Venkatesh. His scholarly contributions also include co-authoring publications on constitutional czars and the Transfer of Property Act 1882. Beyond his editorial and authorship roles, Justice Lakshmi Narayanan has served as a resource person for the Tamil Nadu State Judicial Academy and the Madras Institute of Management Studies, and has presented at seminars held by the Singapore International Arbitration Center and the Nani Palkiwala Arbitration Center. His international acclaim includes representing India in the U.S. Department of State's International Visitor Leadership Program in 2012 and lecturing at Nepal's National Judicial Academy. As a practicing advocate since June 1995, Justice Lakshmi Narayanan has appeared before various high courts and tribunals across India, demonstrating expertise in constitutional, civil, and criminal law, as well as intellectual property and trust law. His prolific writings include over 250 articles published in leading law journals and national dailies, cementing his reputation as a thought leader in the legal field. CIC is honored to welcome Justice V. Lakshmi Narayanan to this forum. Venkatraman. is no stranger to CIC. He has been with us on several other occasions, but it's a pleasure to welcome him once more. He is a distinguished Indian legal professional currently serving as the Additional Solicitor General at the Supreme Court of India. He graduated in law from Madurai Kamaraj University in 1989 and began his legal career under the mentorship of late Mr. C. Natarajan, a senior advocate. After 14 years of working under his guidance, Mr. Venkatraman started his independent practice in 2003 and was designated as a senior advocate by the Madras High Court in 2006. With over 33 years of professional experience, Sri Venkatraman has made significant contributions in various legal fields, including indirect and direct taxes, international taxation, constitutional law, and regulatory matters. His expertise extends to commercial disputes, arbitration, and intellectual property law. He has been involved in cases of substantial public importance, such as Sabarimala Temple issue, Article 370, the Citizenship Amendment Act, and child sex abuse cases, demonstrating his commitment to issues affecting national interest. Appointed as the Additional Solicitor General of India in July 2020, Sri Venkatraman has represented the government in numerous high-profile cases before the Supreme Court. In addition to his legal practice, Sri Venkatraman is a visiting faculty member at the School of Law, Shastra, deemed to be university, where he addresses students on constitutional and national issues. He is actively involved in philanthropic activities, including the establishment of a Veda Padashala and a temple in Tamil Nadu. He regularly delivers talks on national and legal issues, promoting traditional values and addressing contemporary challenges through public discourse. Welcome, Mr. Venkatraman. Our third panelist is Amrit Bhargav. He is an attorney and research fellow at the Shastra Deemed University, India. He graduated in 2017 from the Shastra Deemed University, Tanjavur, with an honors degree in law, completing the course as the best outgoing student of the cohort. In 2016, his book Law and Dharma, a tribute to the Pitama of Indian Bar, was released commemorating the 90th birthday of Mr. K. Parasaran, former Attorney General of India. The book traced the legal heritage of India through a study of its ancient legal system and developments in Western jurisprudence. Amrit has abiding interests in comparative history and international studies. In 2019, he was one of the youngest speaking delegates at the Global Hindu-Buddhist Conclave held at Ulaanbaatar, Mongolia, organized by the Vivekananda International Foundation in association with the Japan Foundation. He is presently pursuing his doctoral studies at Shastra Deemed University in themes relating to law and society, and was nominated as a research fellow with the Tata Palkiwala Chair on Artificial Intelligence and Alternate Dispute Resolution in August 2020. In April 2024, he co-edited the K. Parasaran Miscellany on Legal Wisdom from Valmiki Ramayana and Retrospective, which is the book under review today, which drew from the Ramayana's imprint on legal concepts and contained tributes by eminent personalities about Mr. K. Parasaran. Recently, in June 2024, he spoke and moderated session on international commercial arbitration at the Workshop on Dispute Resolution in Large Industrial Projects organized by the Asian Development Bank Institute, Tokyo, University of Oxford, French National Center for Scientific Research, and Shastra Deemed University. He currently works as an associate in the chambers of Mr. Arvind Pandian and Mr. Harishankar Mani, advocate, and practices in the areas of corporate, commercial, and tax laws. He is also a frequent visitor to CIC, so welcome again. And I have the pleasure and honor of welcoming all our three esteemed panelists to the dais. I'm sure you are in for a very engaging session. And at the end of the session, I would request you to pose your questions to the panel. Please wait for your turn and then ask the questions. Thank you.
Good evening, and thanks to Dr. Chandramouli for that generous and complete introduction. And it does feel wholly different to be on this side of the dais at CIC, and I've enjoyed attending the events in the past, and to moderate a review on the book that I had the privilege of co-editing. And I must add that for CIC itself, this is special in the sense that this is the third time that a sitting judge is a speaker at a CIC program. And the event is also about one of the patrons of the center. The ideas and thoughts, philosophies that have percolated through the experience of putting together this book centers on the personality of a truly eminent jurist, Mr. K. Parasaran. We started this book sometime in 2022, and it was over by the close of last year, with Sastra Deemed University agreeing to publish it as a part of their academic ventures this April. And it almost reads like a sequel to Law and Dharma that was released in 2016. Whilst the ideas on juristic concepts from the Ramayana embody the scholarly part, the anecdotal vignettes and biographical references have added this book into the reader's cabinet of curiosities. The experience of working on this took us to the fundamental questions like what are the sources of law and the relationship between civilizational literature and the legal system. Deriving and distilling wisdom is the work of a seasoned jurist, and we were happy to work as receptacles. This book is in the genre of general, legal, and part biographical reading and contains a specific narrative style. Essentially, the questions that come to us when we review, apart from our eminent panelists who are going to be talking, is what does it take in destiny to manifest a lawyer or a professional as a legend? Are they born or are they made? What is the proportion of that inexplicable alchemy in this story? We might discuss it probably when both of them have finished delivering their addresses. And with that, I should invite Justice Lakshmi Narayan to say a few words on this.
Good evening, everybody. We split the book amongst ourselves because both of us speaking, and in fact I wanted Mr. Venkatraman to start. He was gracious enough to permit me to do so. It's a very interesting work because all of us would have read Ramayana at some point of time in our life. But to look at the work with a legal angle is totally different. For example, this is on the lighter vein, I knew what is in certain places a child would be called a asamanjam. I never understood the meaning. I got the meaning after I read the book. He was an ancestor of Rama. And therein comes in a law of precedence also. So we learn a lot from it. One of the first things I noticed in the book is, which Mr. Venkatraman obviously will expand, is though comparing it with our traditional ideas of king and his successor, the book deals with the king seeking the consent of all the nobles and the public before appointing a person of the character of Rama himself. Thus, please compare this with the divine right of kings that English and European kings were demanding. The king is always right, the law is under him. But here we find, from the first chapter in the book, that Dasharatha goes and asks the people and his advisors whether he has decided to appoint Rama, whether his decision is correct or wrong. They of course approve the decision, but the principle is he did not have a divine right, though he belongs to the Ishwaku clan. His appointment was not automatic, but it was with the consent of the nobles. Then we have dealt with this. I will be reviewing chapter 3 to chapter number 10. Chapter 3 deals with another interesting aspect, which all constitutional lawyers are aware about: equality before law and equal protection of the law. There are two limbs which the Constitution contemplates. Mr. Parasaran has taken it to a further level. He says, what is the difference between importance of a fair trial and what is a trial in itself? Every trial is a proceeding. but every proceeding is not a trial. He would then refer to the ideals which encompass applicable to all legal proceedings and proper administration of justice. There is a lesson to judges also. He says that it is not only important that we acquit the guilty, but it is equally important that you acquit the innocent, but you also punish the guilty. If you fail in either, we are not following the law of Dharma according to Ramayana. Then, interestingly, he would say, if a judge does, for example, the mistake that I cited, if a judge acquits the guilty and convicts the innocent, he says the karmic consequences follow not only for them but for the judge also. Then the chapter 3, it speaks about statecraft and justice, highlighting that a fair delivery system, justice delivery system, is fundamental for the stability and governance in the kingdom. It might be that he might be the best of rulers, but if judges are a rotten lot, then the mistake goes back to the king and the governance itself. Then we move on to chapter number 4, which deals with jurisdiction. The chapter begins defining what jurisdiction means. We have heard you don't have jurisdiction, it is ultra vires, this, that, etc. Jurisdiction is very simply defined as an authority or power of the court or a judge to hear and decide cases. As simple as that. If I have the power to decide a case, I have the jurisdiction to deal with it. The jurisdiction precedes the power to deal with the entering upon judgment. He compares this with the jurisdiction of the court under Article 32, power of the Supreme Court to deal with under Article 32, 131 to 141, interstate river water disputes, and Article 363. Limits of jurisdiction. What is the limit that the court sets on, or court or law sets on that authority? These limits can be on the basis of territorial or geographical. An incident is Vali questions. Is that, hey Rama, you are coming from Ayodhya. What is your right to exceed your jurisdiction and come here into my territory and kill me? So this dialogue is extracted in that chapter. I'm not going to go deep. The beauty of the book is the sloka is given in Sanskrit or the Kambaramayana extract, and I think that's a contribution of Dr. Sudha Seshan. The Kambaramayana original is given with the translation also. So people who don't know Sanskrit or Tamil can follow the English translation that is given there. The answer is very interesting. Rama does not say I have exceeded jurisdiction. He says the entire India comes within Bharata's jurisdiction. I am an agent of Bharata. It is my duty as a king, it is my duty as an agent to uphold Dharma. And therefore what you have done, trying to entice your brother's wife, invites punishment of death. And therefore he punishes. This answers two things. One is jurisdiction to deal with, to render punishment to Bharata. And the second is, as a dutiful king, he has punished him with what he deserves. This chapter 3 and 4 go together. Then it also comes the role of Bharata in this. We are aware Bharata took charge as the king. But where did Rama get the power to punish? Rama says, I am a delegatee of the power of Bharata. So that also brings in the concept of contract, or the principle of power of attorney, where the agent exercises the same power as the principal. Hopefully Bharata would have approved the act. And then the next interesting aspect is the Vanaras. The Vanaras, they come to know about the act of Ravana in abducting Sita. They do not, they are immediately, instant reaction of the Vanaras is, let's go and destroy Lanka. On the advice that Jambavan gives is, express restraint unless and until you are given explicit orders from either your king Sugriva or the ultimate leader Rama himself. And then it also deals with the concept of limited authority, saying, what is the principle of ultra vires? If I exceed my authority, I have acted in an ultra vires manner. Therefore, the advice which Mr. Parasaran quotes in this book, in this chapter is, it illustrates the principle that public authorities should operate within the limits of your jurisdiction lest they invite karmic consequences, as he dealt with in the previous chapter. Chapter 5 is more for lawyers. It deals with law of precedence. What is a precedent? So and so has decided a case. A similar fact situation is given to me. I will decide the case accordingly. I will follow the precedent. This is, all of us were under the, at least those trained in common law tradition, as most lawyers are, we follow the principle, it is called principle of stare decisis. That is to adhere to decisions and not to disturb or unsettle settled positions of law. This is the fundamental basis of law of precedence. He said, Mr. Parasaran says, Rama also used precedence while deciding cases. He would refer to sage Kandu and Sagara, who would accept historical acceptance of the paternal command in challenging circumstances. This I will deal with in the later portion of, it is dealt with in the later portion of the book, which also I highlight. He had an option, Rama is told, listen to Dasratha. His mother comes and says, listen to me also. So Rama cites this instance, says, if a parent asks you to do it, obey it without being bothered about the consequences, though it will be in challenging circumstances. Now, I don't think we can expect children of today to do that. Then he also says, where there is a conflict between a mother's command and his father's, Rama says, where sons have obeyed the father's command even against their personal beliefs. Yet again a principle, he says, my predecessors, that is the Ishwaku clan, they have followed the precedent of obeying their father's command. I will follow my father's command and I will go to the forest, even if it means I am going to supper. And this is where Asamanjas comes. Kaikeyi invokes the story of Asamanja to justify Rama's exile. It is countered by Siddhartha saying, there is a difference between Asamanja and Rama, emphasizing Rama's virtue and faultlessness compared to the vices from which Asamanjam was suffering. Finally, there is a very interesting portion of this book which I did, sometime I was working with Mr. Nariman, Mr. Fali Nariman. I used to rush to him with authorities and say, here, there's a direct point on this. So he used to tell me, if a judge is not with you, he will find a million ways to distinguish that judgment. This book deals with it, where Siddhartha says, Rama's case is different from Asamanja's case due to the fundamental principle of moral characters and circumstances. He would also say, to uphold precedence, it should apply only to facts and circumstances of the case. So next time a lawyer comes and argues and I find a difficult precedent, I can cite Rama and says, it doesn't apply to the facts and circumstances of this case. And finally, a very interesting aspect on precedence is, it provides answers to ethical dilemmas and legal reasoning. These notes capture, at least the chapter captures, the law of precedence as depicted in Ramayana, highlighting its relevance in resolving ethical disputes, and serves as a guide to both lawyers and judges while citing precedents. And next chapter deals with mens rea and actus reus. The manner in which the book deals this is very interesting. Hanuman is deputed to go to Sri Lanka to search for Sita. He first jumps into he crosses the ocean and goes to the palace. He searches the palace and finds several beautiful women sleeping. And then when he sees this, Mr. Parasan gives his interpretation saying, he was not gazing with an evil intention. He was gazing at them to decide as to whether this would be Mother Sita herself or not. Here he says the intention of Hanuman, mens rea, was not with any evil thought with the women who were sleeping. They weren't aware he was around, that Hanuman was around. He was tiptoeing. But still, Mr. Parasaran says, we have to look at the intention of Hanuman, which was searching for Mother Sita, and therefore he had no mens rea for the purpose of committing any illegal act. And then Valmiki's description, he says Hanuman's intentions were pure and lack of impure thoughts are pivotal in determining his guilt or innocence. This I think would be useful even today. And then he gives the example of Sugriva, who became a king not out of personal desire but out of external pressures and necessities. This lack of, he did not want to depose his brother. There was a pressure on him. So, in this chapter, the author says, lack of intention, that is mens rea to usurp the throne, illustrates how mens rea affects the guilt in actions. And overall implication is that both physical act as well as the accompanying mental state are crucial. If either one is absent, then you cannot go ahead and pronounce the person guilty. Okay, the next, I'll just rush through. The next is on reflections of law. This is a very interesting chapter. Persons who get the hands onto the book is better you read it independently, because it has all the aspects on the Sugriva's complaint, Rama's Vali's legal challenge, Rama's reply, and the conclusion. The end of it, he is the affected person. After the explanation from Rama comes, he acknowledges wrongdoing, finds peace, and requests Rama to take care of his son Angada. Then the other two chapters deal with principles of natural justice and law of contract. Natural justice, I was always under the impression it was based on Christian principles, that God did not banish Adam or Eve from the paradise without hearing them. This was audi altrum partem, as all lawyers are told. But Ramayana, which is equally old, he would illustrate not only the right rule of fair hearing, rule against bias, rule of hearing, reasoned decision, which is a heartbeat of every judgment, and essentially about seeing the post and pre decision making process. He says all these are covered in Ramayana. And finally, the law of contract, which all of us are aware, it was a contract between Dasaratha and Kaikeyi, saying that I'll uphold I'll give you whatever you want, and she extracted a pound of flesh. So the principle being that the conditions of the contract which was entered into, you should read carefully before you accept to it. Ramayana provides insights on law of contracts through Dasaratha's covenant with Kaikeyi, highlighting principles of necessity of clarity and adherence to contractual obligations. And the last chapter which under the review is about the art of advocacy. There are two instances they quote. One is Hanuman exemplifying his advocacy when he meets Rama and Lakshmana on behalf of Sugriva, and where he praises the eloquence, proficiency, and the grammar. Flawless, demonstrating the importance of language and command in advocacy. And conclusion on the chapter concludes with Hanuman's advocacy, saying it is important. It divides advocacy into three parts: Vada, substantive debates based on principles; Jalpa, based on logical arguments; and finally, which we always say Vidandavadam or Vidanda, to defeat the opponent without substantial arguments, often indulging in personal attack. The chapter ends saying, quoting Bhagavad Gita, that advocates should engage in Vada and not in Vidandavada, depending upon the context. Thank you.
That was an absolute master class and a critical review of what is contained in the book, the chapters that were dealt with. So I would request Senior Advocate N. Venkatraman. He's been introduced adequately by Dr. Chandramouli, but I can just say that Senior Advocate NV is the envy of everyone. So, the floor is yours, sir.
Thank you, Mr. Chandramouli, Arvind, Dr. Vaidya, CIC, and those who are instrumental in organizing this event. When Mr. Chandramouli spoke, he narrated, the idea is to have, Amrit was very clear, sir, give us some takeaways out of this book and about the life of KP sir. That's the designated role for us. 7 years of practice, 7 decades of practice, in which 5 decades he peaked. 3 very coveted position one can aspire as a lawyer: an Advocate General, a Solicitor General, and the Attorney General of India. the recognition by the government of India, the highest one can think of, Padma Bhushan, Padma Vibhushan. Member of Parliament for one full term from 2012 to 2018. So it sums up the plurality of dimensions of a distinguished person in public life called Mr. K. Parasaran. But the first takeaway for all of us, and it needs to necessarily be conveyed to our children, is his grandson, who's doing intern with us, said this. Sir, I used to wonder, my grandfather will wear a simple dhoti, a simple banyan, and people used to eulogize him. As a grandson, I used to wonder, why are they doing this? But after finishing school and when I stepped into Jindal, when my classmates started to say, do you know who you are? Then it actually broke a dimension in my life to understand what really is my grandfather. So the first takeaway, as KP Sir wore the robes to stand up majestically in the Supreme Court to address, every role which he adorned, he did not convert that into his personality. He kept a distinction between what he should be in his life and what he had done wherever he was required to do. This moral is very, very important for all of us. Never confuse what you are with what you do. If you superimpose what you do as what you are, you will get deceived at some point of time. First takeaway. The second takeaway which we should bear in mind is the kind of achievement finally Parasaran Sir did to show to this world what he meant to Bhagavan Sri Rama and what Bhagavan Sri Rama felt about his own Shishya. See his graph in the constitutional benches, starting from Minerva Mills on basic structure, travels into Indian Express, where as a Solicitor General he came to the court and said, Gurmurthy Sir records it, you will have a new counsel to argue, I'm not going to appear for the government. And instead of showing him an exit door, the government rewards him with Attorney General for his position. The professional ethic to stand up for your cause, for your convictions. Then you travel into the judge's case. You travel into Bombay, the huge decision on governor's powers. You travel into TMA Pi. You travel into the 1998 presidential reference. You travel into the Federation hotels on taxation. Then you go to the NJAC. Then you travel into Sabarimalai and culminate in Ayodhya. What a life. What a life. Prime ministers have engaged him. Presidents have engaged him. Chief ministers have engaged him. Governors. Common man. But the pinnacle is his final recognition for his 7 decades of service to the nation, to the clients whom he had to answer, is finally, this is what Gurmurthy Sir writes in his accolades. Finally, Bhagavan Sri Rama chose him as his senior counsel to represent himself in the Ram Janma case. The rest is all human effort. But picking a person for his own assignment is what Parasaran stands for. Now we come to the third segment. The beautiful way this book has connected both Bhagavan Rama and Parasaran Sir. This book is not an autobiography, neither an autobiography on Bhagavan Sri Rama or an autobiography on KP Sir. The principles for which Bhagavan Sri Rama stood gets conveyed in this book. and the principles and the values which KP Sir stood all throughout his life gets reflected in this book. Therefore, we can see plural dimensions, multiple descriptions about KP Sir. But this is one unique book which brings a very unique dimension of KP Sir. KP Sir lived the life of an epic life of KP Sir. This book is for that. Now, how does it connect the governing principles under a kingdom which are applicable even today to a modern democracy? This is the book one should read to understand, and it connects the values for which KP Sir stood. For example, it says adherence to dharma, one's own dharma, is secular and not spiritual or religious. There is a complete misunderstanding today by the younger generations on this, because they all believe secularism is anti-God, showing yourself to be anti-God. It's not so under our constitution, not so as portrayed in Ramayana. 2. It says, in a democracy, God and religion are not excluded. That's the guarantee in part 3 of our constitution. 3. It says, a man can be punished for a breach of law, but he can be punished only for the breach and nothing more. Now, what is happening today in the name of trying to simplify the criminal laws across the world? See, globalization has taught us 2 valuable lessons. Globalization gives instant growth, but a hidden decay over a period of time. So if democracies don't assimilate that hidden decay, then one fine day you will be pulled out of the system. You will be just unplugged. And it has happened for several nations. And the 2 great threats are corruption and leniency in issuing actions, punitive actions in inappropriate cases. These are the 2 valid reasons for decline of any nation. So this book deals also with that. And most importantly, it's about 35 pages of description, but it tells you what you need to know as a leader, as a citizen, as a service provider to the nation, what you need to know as the rules of governance. It captures 12 important, I'm not going to read the internal ingredients, but you should all read it. Virtues of a ruler. What is good governance? The 10 types of evils, the 5 types of fortresses, the 4 essential strategies of governance, the 7 elements of a state, the 8 manifestations of an anger, 8 measures of welfare, various branches of knowledge, 6 strategies to be employed against the enemies, the evils of human agency, the calamities which can occur on a nation, and the 20 classes of rulers whom a nation should never take friendship into. See the spectrum this book covers. Now, what is important is the second part of the book, which eminent luminaries and public personalities, in one sentence, 5 or 6 of them needs to be referred here, what they speak about KP Sir. For example, if you see this, if you see what the ever-inspiring Chief Justice of India, M.N. Venkatachalaya says, his commitments to constitutional values and human dignities stand amongst the supreme values of his life and law. What does Fali Nariman say? No one now to emulate him or to excel him in his matchless performance. What does our present AG Venkatramani Sir says? Ayodhya case is a reflection of what he stood for in all his professional life. No liberal or progressive voices can write off these aspects as fading facets. What does our former AG KKV sir says? He says three things, very important. He says, the submission which KP sir did as Solicitor General in 1980, 45 years ago, the paper book and the case laws is being preserved by KKV sir even today after 45 years. And he has used it to give an opinion as an AG for one of the election matters, which he has used this paper book. 45 years somebody has preserved it. Somebody who has stood and argued against him most of the years, in most of the prestigious matters. This is the kind of a respect which an opponent counsel who has been consistently opposing says. And he says in his accolades, he refers to two important appreciations, one delivered by the Madras High Court and one delivered by the Constitutional Bench. And what is important is, the reference of appreciation by the Constitutional Bench was not on constitutional law, nor on civil law. The court went ahead appreciating KP sir in interpreting section 433 of the Criminal Procedure Code. See the uniqueness he has. The appreciation he got was for that, not for his usual domain expertise in constitutional law. So KK sir extracts that. What does Naniji say? Naniji says, I always like to have you as your opponent, as my opponent, because you will state the case as high as it can be put, but at the same time, never try to take an unfair or unjust advantage of the other side. I wish other government councils would follow your laudable example. My last 3 minutes, if I have time. Our personal the experience, the relationship between my senior, late C. Natarajan, and KP sir is something I need to refer here, because it was a relationship of mutual love, mutual respect, and mutual trust. A very, very unique bondage they shared, and a couple of instances needs to be put in this public domain today. When KP sir left the office, our senior was then not a senior, because he was delaying it as much as possible. One day he was thrusted by Justice K. Swami, you should become senior from tomorrow, and that's how he became a senior. So he engaged him in a constitutional matter before the court in the Cannon Duncanley case. One of the judges from the Madras High Court as Chief Justice was elevated then, and he was in the bench, the junior most of the Constitutional Bench judge. So before raising, he made a request, Mr. Parasaran, I have told my brother judges about Mr. Natarajan, so will it be possible to also hear him? So KP sir immediately said, it would also be my pleasure to listen to Mr. Natarajan. So they broke for lunch. But when they came at 2 o'clock, our senior stood up and said, I have engaged KP sir for this matter, and protocol demands that I should not argue. The relationship started to grow in strength from that point of time. We did a Guru Vandanam program in honor of our senior in 2016. And the precondition which late C. Natarajan, who is known, he is such a person, he is a roaring lion in the court, but a very shy person otherwise. He said, no judges should be invited. No seniors should be invited. You should only invite people with whom I have been interacting for 40, 50 years. Nobody else. And let it be very informal so that I meet and talk with them. So we did not invite judges or seniors. And see the gesture extended by Parasaran sir. He landed into that event uninvited with Satish, and took to the podium and spoke for 30 minutes about our senior, saying that this is the event for my friend Mr. C. Natarajan. I don't wait for invitations. The human angle of KP sir there. We were just shocked how to handle the situation. When a mighty man just storms into your event and says, I have come here, why should I need an invitation? In 2003, when I started to have my individual practice, it was June we started. In November, December, we engaged as the first big matter somebody gave me in the Supreme Court. So we went to KP sir to engage him. He heard us for about 45 minutes without any response. Absolutely no response. I was shocked. The first brief, such a big brief, somebody's trusting me. He said, come tomorrow, I'll tell you. Then he never told the reason that day. When I went next day, he was so pleasant and he was so receptive. And the reason he gave was, you were a junior for 14 long years with my friend. So it is but ethical that I first talk to my friend to say whether I can take this brief. You may be his junior, you may have come for an engagement. Look at the ethics he follows and see the response of late C. Natarajan. He has conveyed to him, Venkatraman has just started his own practice and I'm happy he's engaging you. Please do the best for him so that he comes up in life. The relationship they share. The last two, which is interesting court experiences. There was one assessee who had 6 income tax assessments, each one running to thousands of crores. Huge matter. So what he did, he engaged 6 senior counsels for 6 assessment years, starting from KP Sir and ending with me. This happened in Justice Kapadia's court 15 years back. So I was the tail ender there. It's a 180-page judgment. So Parasaran Sir is known to go and occupy any court 20 minutes before. So he was sitting at 10:10 there and when barged into the court at 10:20, he was asking me, Ennada fulla padichtiya? So 180-page judgment. Sir, whatever is possible I have read, sir, I can assist you in whatever way. And he pulled out page, I remember the page 138, and showed it to me. What is your answer for this? 15 years back, Parasaran Sir was still 82 years. He was not 15 years, 50 years. 180-page judgment, line by line. I was stunned when he showed it. So 6 of us stood up, item 1. So when 6 of us stood up, see the way his advocacy. Lord, 6 assessment years and 6 senior counsels, we have come here to point out several flaws. Each one of it can do. After all, it's a 180-page judgment. It can't be without flaws. Admit it. The last one which I thought I should say. We were arguing, Sir was to argue for Sriram in some other matter. I went for a software company in a high court. So I was trying to explain with great detail to the judge how Constitutional Bench has viewed a software matter. Says intellectual property put in the media becomes goods. This is what the statement I made because that's what the Constitutional Bench says. The judge heard the word media. So he said, everything else is now vanished. So she asked me, Venkatraman, media, whether it is television or press. I just didn't know what to do. KP Sir was next. See the guidance. He pulled my robe. Just say, I'll find out and take time. Adjournment was the only course open then. I didn't know what to do. He didn't hesitate. He pulled my leg. Just say, I'll find out. And he would have done it only that way. So, we can speak about this man and his glory for any number of hours. And children should definitely read this book and read both parts, line by line. And we should thank Dr. Sudha Seshan, our Amrit, our Shambhu Shivashastri, and our Siddharth Krishnan, and to top it all, Dr. Vaidya and Shastra University for delivering this epic work on an epic man called K. Parasaran Sir. Thank you so much for this great opportunity.
So now we understood how we have a senior counsel here who, when starting preparation extensively for a brief, doesn't know if it is day or night outside. So when listening to this, we also understood what are the other parts of the book that have resonated with readers, and we're extremely grateful for these comments. And now to some points that I thought I should engage our speakers with. I think there is some more time, and starting with just a
Start
second.
with him. Start with him.
So, one point that keeps surfacing while editing the book and thinking about it repeatedly was the relevance of ancient law to the modern jurisprudence as we know of it today. We are living in times where if we have to search for a copy of the 1956 Companies Act, no shop sells it. So when that is the kind of degree of obsolescence that is prevalent, how do young lawyers or law students perceive ancient law? In fact, probably the time when your father also did law, Roman law was a subject. And there were medals in Roman law at that point of time. And now, of course, we have a maze of guidelines and delegated legislation that we have to learn and cope with. So, your views on the relevance of ancient law in today's times?
In fact, speaking about Roman law, I don't know whether Sati still has that book. Keshava Iyengar's book on Roman law and Indian law. There is a work which he has written. Mr. Parasuran's father, late Sri Keshava Iyengar, has written a book comparing Roman law with Indian law. It was available in my father's library. It was gifted by Mr. Keshava Iyengar. So why is it relevant? The new acts might have come. New principles might have been developed by the court. But the fundamental framework has not been changed. I give you the example of principles of natural justice. They have not changed right from the time a formal legal system has been in place till date. So unless and until you understand the basis on which that principle had started, you will not be in a position to apply it today. For example, the civil law. Not many people are interested to read civil law. Everybody wants corporate law or intellectual property. Transfer of Property Act, Specific Relief Act are being ignored, which is the origin for writ petitions. It was section 45 of the Specific Relief Act of 1877. The principle of justice, relief of declaration, it started at Scotland, went to England, came to India through Code of Civil Procedure, finally is found under Specific Relief Act. So you necessarily have to understand the ancient principles before you try to apply them. You have to read, and that's hard work. But without hard work, you can't come up in this profession.
So now, we as youngsters, I think, have an onerous duty of first reading and then coming to court or preparing for opinions. And now a question for NV sir. This is about how legends are made. There is no one answer to this question. And there are two parts. The first part is about how do you make a holistic professional? Like sir was saying, everyone wants to be in international commercial arbitration. Everyone wants to do bankruptcy and restructuring. And, well, what happens to the other areas of law? There is also specialization. How do you make a holistic professional who ultimately transcends into that legendary status? That's number one. And number two is, of course, on the anvil of your own experience as a law officer and on a very eminent jurist who is also the subject of the book, a comparative analysis of sorts.
See, we'll take both the questions one after the other. It's if you want to become a successful lawyer, you should be blessed to have a successful senior. Simple.
Very true.
Very simple. See, this is not a college model or a school model or a university model. It's a Guru-Sishya Bandham. What late C. Natarajan taught to us and what he lived as a lawyer inspires us more than how to find a case law to match or support your case. See, when my senior stood for simplicity, my senior stood for integrity. No compromise on integrity. Judges never flipped into the pages to find out whether what he argued is fact. They trusted him. That trust building with the court. So, When you start learning it at 23, 24, it will become part of your life. It has nothing to do with a case. It has nothing to do with a client dealing. So, this work holistic is not just becoming a successful professional. The first lesson CN taught to us was, look here, you must first be a good person before becoming a good lawyer. The second lesson he taught to us was, never chase money in life. The third lesson he taught to us was, when you take your wife to a doctor, will you not expect the doctor to show full attention on your wife to treat? You should treat each and every client that way. Big case, no, don't specify times for big cases or small cases. Whatever time a case needs, that time has to be spent. See, this is holistic life of imparting. A guru sishya banda. This is important for younger generations. You all come here 1 year, I'll be here, 6 months, I'll be there. In third year, you should be the most successful lawyer. And fifth year onwards, you should say. So today, there is plenty of work and there is plenty of money with little efforts. So it is very, very an anarchical contradiction. You have to believe in it. You have so much work, you have so much money, but you don't have to put efforts to earn it. So where will you put efforts? How many of you are ready to read a paper book of 4,000 pages? Why is a trial law dying? Why is brief pleadings being drafted? See, what I love with the learned judge today is, he was so brief and to the point, and therefore as a young judge we will certainly hope that he will write brief judgments. You write 300 pages, who is going to read? It will get admitted in the Supreme Court because it is 300 pages. So this is holistic life. Now to be a person like KP sir is not just being holistic, right? You live a life of conviction. He was talking about why ancient law. Look here. This is what our spiritual guru, the saint of Shringeri, has taught to us. Dharma and adharma will continue to remain as only dharma and adharma. Can it swap places? What was adharma yesterday, we'll change it and make it dharma. And what is dharma today, we'll make it. We can't change it. So once you can't replace these two, the two epics of Ramayana and Mahabharata, which preaches Satya Dharma, has to be understood by rote by each one of us here. So what happened between two brothers, warring families, happens every day in the court. So how is that Mahabharata is not replicated? How is that instance of Ramayana not replicated? And therefore you need to deal it to a court process. It may be a democratic process. It may be a constitutional process. But the underlying Satya Dharma is what legal profession is all about. So this book is therefore an evidence for that. It's a very inappropriate question. See the relevance of Ramayana, which talks about secularism, and see how Constitution guarantees it, and see how people in public domain project it. And as youngsters, should you be caught with a statement which is very attractive, or you should go to the root of the Constitution to understand, does it really reflect so? Parasaran sir has done it every time. That's why he is a legend. He never believed in somebody's statements. He believed in making his own statements with conviction after reading what the truth is all about. A legend never borrows ideas. A legend never lives on borrowed feathers. He runs his own life in his own terms. Who will have the guts to stand up in 1982-83 to stand up and say, as a Solicitor General, I won't appear in this matter. Let government think whatever about me. And he becomes an Attorney General for that. This is the difference between a professional and a legend. This children should try to understand. Thanks for this question.
In fact, talking about the professional ethos which has been handed down in this field, there is one anecdote which Senior Advocate Arvind Dattar has narrated in the book, which I'll take the pleasure of reading. And I quote, Parasaran also told me a remarkable story about how a Bombay solicitor first came to him to settle the plaint in a complex partition suit to be filed in the Bombay High Court. Parasaran told the solicitor that his father was the right person to settle the suit. The solicitors met Keshava Iyengar. He told them it would take 30 days to settle the plaint and asked them to leave all the documents with him. 30 days later, the initial 50-page draft was reduced into just 8 pages. The solicitor was stunned. Keshava Iyengar told him that the more one writes, the more one is likely to make mistakes. The 8-page plaint covered everything. The anecdote does not end here. Keshava Iyengar told the solicitor about the 3 possible defenses that the other side was likely to take and what their strategy should be. Eventually, the plaintiff succeeded, unquote. This has a lot to reflect on many counts, and one of them is also about the evolving paradigm of legal education. Ultimately, what gets into our heads is on 2 fronts. One in law school and the other is in the profession. So, your comments on that?
What you learn in law school, you don't practice in court. Apart from, of course, writing. I went to National Law School, Bangalore. We really had Rahul Balaji was my classmate. Literally, we had an exam every 7 days, if you calculate. Either it was a project or a viva or a midterm or a final term, and we used to follow a trimester pattern. It helps because if you put your nose to the wheel as a student, when you come into the profession, it will help you to sit the long hours that you have to as a lawyer. But we have to change our law school pattern, the manner of teaching. As you also noted, everybody wants international arbitration. Everybody wants to argue a review of Keshan on the Bharati, and that too within 1 year of enrollment. It doesn't work. I mean, if actually a client wants to a matter to be argued by a stupendous constitutional issue, he's not going to come to a greenhorn. He's still going to go to a person who's experienced in the field. Therefore, law school must teach students to face failures. If a writ petition is dismissed or a revision is dismissed, you can give your heart out and argue. As a lawyer I would have used a different term, but if the judge doesn't agree to it, then you don't have an option. You just have to accept it and walk out. In the book also he writes, the counsel can put their point as firmly as possible, but in a polite way. If the case is lost, don't lose the judge.
I just add one, because there are a lot of children here. We will cite KP Sir's experience working with him itself. This case which I said in 2003, which he took. See, it was in December, winter. Okay. In 2006, Sir should be, say, 18 years, which will still be 80 plus. So, he gives a long conference that evening, 4 to 6:30, with the usual good filter coffee by his person who does it for so many decades to him. At 10 o'clock that night he calls. As I was going through, I'm getting a doubt. What is an answer for this? And says, next day morning, please come at 10:10. I would like to have a briefing for 20 minutes on this. So you go next day at 10:10, meet him and brief him for 20 minutes. See, when the matter, it came before Justice Rumapal, is a very tough judge. So when it came before her, ladyship, he stood up and said, in my humble opinion, this judgment is wrong, it should be stayed. And judgment got stayed. See, to say, you must understand this. This is exactly what children should understand. See, for a man to say this with conviction and for a judge to believe, you can't say this flipping a few pages and make that statement. You may hit it twice. Third time you will get caught. To say that one sentence, the man slogs for 6 to 8 hours. A small brief of 150 pages. This is what is hard work, focused work in a profession. Now, we are not ready to do that. We are not ready to do that. You have so many distractions, which if you want to be a professional, you can't get distracted. It's a choice you have to make. Now coming to the university model, not that I know Dr. Vaidya for so many years, not that I speak there very frequently. It's my duty. It's not a promotion. Nobody needs any promotion. But I can tell you, 3 children from our family are students of that university. And all the 3 have taken to litigation very seriously. This interest, this passion for working and doing court work is something which, if a man with that ability drives it, then it will influence the children who undergo that tutelage. This is very important, the drive. So it's not a question of model. We are all now bound with standard models. We can't change it at our own will. But you can still tweak the model to the benefit of the children to understand what you need, the emphasis in the model.
One thing I noticed from what you said, lot of students from Shastra come to litigation.
Without a
But
doubt, sir.
very few students from the national law schools come for litigation.
They all go for corporate
It
jobs.
was created in order to improve the bar. But they have gone for corporate advisory or for working for foreign firms or becoming general counsel. They don't come to
But
litigation.
still, to inspire even such students, the first judge of the Supreme Court, Justice Datta, is the first student from the 5-year integrated national law school from Calcutta. He adores. And now, sir, different high courts have judges who have come from NLS, different NLS. But what you say is technically and factually right, that they prefer, because, see, ultimately, because children are here, what the ideology that influences you also models you in your life. So you have to be very careful.
I'm sorry to interrupt, but there is one follow-up which after which we will also throw open the floor to the audience. The question which I sort of hinted at the beginning was holistic professionals and lawyers who have what we call quote-unquote stature, and there is a meaning to that word, is not just about education, profession, but also something that we cannot describe in words, which they are the doors of destiny. And those are not in their hands. And the real follow-up which I wanted to ask you was, there is a lot of balancing between a government law officer's work and private practice.
I will put it this way. I will reframe it for everybody's. He has put a very subtle question and a very, very pertinent question. Is your life driven by destiny or it's driven by your hard work? I think let's put it that way so that people understand it. We must believe it is driven by both. Only then you can stay beyond a point of success. If you believe everything is manageable with your human ego and with your human effort, well, you can reach a point, but not beyond that. See, ultimately, unless you become a tool of God, you will not be chosen for great assignments. You may believe it, you may disbelieve it. That's your choice. We don't have a problem there. Unless for which you must trust in things which is beyond your control. You must trust in things which is beyond your visibility.
Right.
It is very important that we learn it at a very young age in life. Okay? So, but okay, the converse is there. Okay, there is invisibility, there is God, He will decide everything, therefore can we sleep? You can't sleep. You can't sleep. You can't change the outer circumference of life, fate, prarabdha. You can call it whatever it is. But your inner wheel is always, every birth, human birth, you are given a free will and a fate to manage your fate. So how well you surrender your free will to God's will determine where your destination is. KP Sir is a typical example. Did he not work? But he believed in Rama. Did he not work? He believed in Satya and Dharma. No compromise on integrity. No compromise on ethics and values. Quick money, quick success, all this is achievable. It's available at your doorsteps, but you can't transcend beyond a stage. There is only one KP Sir. There is only one Naniji. There will be only one M.N. Venkatachalaya. You see their biographies. They stood as tools of God. See, our Guru, when he was blessing Adi Yogi Raj from Mysore, who sculpted the Bhagavan Sri Rama's Vigraha, he said, as what Gurumati sir wrote about KP sir in picking him for the assignment, he is chosen tool to carve out that statue. It is so blissful to watch anytime, every time. Because Rama chooses what he wants to do and he will find a person to do it. Should we become that person in our profession, then you must have a life combination of your hard work and belief in God. Disappointments will come, frustration will come, humiliations will come, insults will come. But if you are a chosen tool, you will transcend all this one day and to show to the world what God wants you to deliver. This faith children should have. It's a request. It's up to you to take it or leave it. You should part it.
Take some questions, sir.
Certainly, certainly.
Provided we know the answers.
God will help us.
Kindly raise your hand if you want to ask a question. The mic will reach you.
My namaste to everybody in the dais as well as the visitors here. First, my name is K.M. Naranistri. I am senior advocate in Madras High Court and we have been in the legal profession. Satish knows, even our judge also knows, that for the last 100 years, more than 100 years, our family is in the profession. And my grandfather was the contemporary of our Keshava Iyengar, and KP sir was with my uncle, and rightly now with Satish and all me. One thing I want to highlight here is, which I cannot forget in my life, before our KP sir visits to Ayodhya, I had a privilege to meet him to seek his blessings. Because we cannot go and attend the function, but he is going there. Indirectly we can derive the positive energy from him. I went and met him after talking to Satish. I could not just come to the world. He called me that I told so and so. And then immediately he asked me, your tata, he talked to me in Tamil, unga tata rendu kaadum kekadu ana inga Madras High Court vandar thirumbi poitar Nagapatnamukku. I'm sorry, he went back to Nagapatnam. Avar inga continue aayirundha nala onnume illama. I was astonished because I don't realize that he would be remembering my grandfather. And he was very cool. He said, நான் உங்களை தொந்தரவு பண்ண உட்காருமா உட்காரு, உங்கள்கிட்ட நிறைய பேசணும், உங்க தாத்தாவை பத்தி நீ தெரிஞ்சுக்கிறியா அப்படின்னு. Because I was so small, I could not. He was talking like this. So you would have been outsighted from Madras High Court or any judiciary if your grandfather had a good audio hearing. I was so stunned. Then he told me, I asked him casually, sir, what is your, just how you are spending your time? Because Satish and not busy in the office. I told him, I want a suggestion from you. No, on the legal subject. Anything for your welfare, how to grow, I'll tell him, but not on legal subject. Okay? See, this is here the KP sir lives in my health or mind wherever I go. I cannot forget him because how he traces his history in the legal as well as as you said, the binding in the legal bar and the family, which he did, I cannot forget. I want to register it here. It's my proud moment that we are attending his function. Thank you.
Anyone else has a question?
Children there, anything to ask? We'll try to learn from you.
Yeah.
Good evening, sir. So, specialization over diversification. What should an young law student pursue, sir? Whether a specialization or diversification of law subjects?
See, I started practicing tax law because my senior practiced tax law.
That's all. That is all.
So, it's a casting, okay? How fortunate you are to get into a particular casting. you shape in that caste. But it is better to have expertise in some areas, so that at least a set of people try to identify you at some point of time. Being a generalist has its own advantages, but it has its own disadvantage. Client building today in the modern world happens only if you are a domain expert. Instead of client building, you build on your own strengths and let clients come, then you should opt to be a generalist. This is my personal understanding of the issue. It's my personal view.
Namaskaram to all the panelists. My name is Daita. I'm from Shastra Deemed University. I'm in my 5th year now. I'm going to be entering the law field and practicing it in another 1 year. First of all, it's even a privilege to be talking to this panel right here. So for that, I'm extremely grateful. I don't know whether this is a question but this is just a ponderance that has been going on in not just me, but my entire batch for that matter, because we only have a year left. There are a lot of confusions with regards to what we want to do, whether we want to get into corporate practice or whether we want to do litigation, because as much as there are a lot of students in my batch who love litigation, including myself, there's a lot of practical issues that we need to take into consideration before we make such choices. Such as family backgrounds, then even monetary issues for that matter. But that's one of the ponderances that we have been having, because as much as we love litigation so much and majority of our internship experiences involve just litigation, many of us go into corporate practice because of such issues. So in that situation, do you think we are supposed to leave things to the universe or the higher being and do our hard work and get into litigation and do the field that we love? Or what would you say, sir?
I'll give you an answer which will shock you. So,
Okay.
Actually, personally I'm saying it, I'm in search of 3 to 4 good hands for my work. And for 1.5 years, I have not got one. Struggling. 4, there is space for minimum 3, then I can come to the 4th. And fairly, properly remunerated, don't worry about that. No talent available. Just lying vacant. We are struggling. In this 1.5 months, we have settled close to 1,200 opinions to the central government. Can you believe? So, this is the problem, which Nani said 40 years back, Nani Palkiwala. Employability is the problem, not employment. Okay, that's the catch. Abundant numbers of people will graduate in every profession, but only the few finally make it. If you are within that few, and if you are hardworking, see, God will not come to your help unless you put your resource. That's the precondition. Don't think God will come first and you will go behind it. You will have to put your effort. If you are sincere, dedicated, and you are passionate about, the doors of life will open for you. This faith we must have. But choosing the profession or choosing a career, it is very, very circumstantial. To be very honest, that's the fair and a factual answer. Can you afford a long wait? Can you afford the duration? Is something. Will your family support? That's the second question. If all these factors are supportive of your thought process, then you should plunge. Because one thing we can assure all the young lawyers, there is plenty of opportunities. We are not short of opportunities. But we should click. That is not in your hands. But working for those opportunities is very much in your hands. If you work, you will be rewarded at some point of time. This is what life has taught us. Thank you.
Yeah, essentially it's a choice which you have to make. The point is, if you are looking at quick money, corporate sector pays you well.
Answer.
But if you feel that you have it in you and you will, I used to work with a eminent lawyer by name A.J. Abdul Razak. He used to say, if you survive the profession for 7 years, you're through. And you just ask any other, if a person has managed to put his head to the wheel for 7 years, you will find that invariably he'll continue in the litigation and he'll reach some place. But if you fall off midway, or if you think you can't hold on for 7 years, then it's better you go to the corporate side. This is not, he said that, I've seen many lawyers thereafter also. The initial period, of course, is difficult. But if you have a family, my brother is a lawyer, my father was a lawyer, his father was a lawyer. See, your possibility of getting the brief in your hand is easier. But still you have to deliver the goods before the judge. Merely because my father or a brother happens to be a judge, the judge is not going to give me an order unless and until I am prepared. So if you prove yourself to your senior, you will automatically get briefs. And with briefs comes money. Don't put money before the brief. You have to prove yourself to your senior. There have been juniors who have done very well within 2 years. They have started arguing. And there is a certain amount of luck and the grace of the Almighty. But if you are looking at quick money, and you remember there is always a glass ceiling in the corporate sector, much more than what you find in the profession.
He was asking, Mr. Chandramouli wanted, because youngster said he wanted me to address also on AI, whether that will be a threat, GPAT and all that. See, when railway reservations were only manual decades ago, now it's all online. Is there a threat to employment? Is there a threat to our life? See, any amount of machine substitution can help us, but I think nature this far has not allowed a perfect substitution to throw somebody out. And I think sovereign nations may not induct that finally. So any amount of AI can't substitute a good junior, but it will facilitate. It will see the kind of case laws which we searched in 1989. We had, if ITI, it was some 160 or 180 at that point of time. If you have to search a proposition, you will first go to a digest, find out something, some keywords, clue words, then go to pick up those ITRs on your table. This is what we have done physically. Then start flipping those ITRs. They will connect you to some other case laws. Then take that. Then go to AAR. Then go to. This is how we built case laws. Today, if you just click a button, it all gives you. And we have been party to AI demonstrations. Several people have come and done it with AG. We all were parties to it. See, it certainly hastens the process, but it can also be inaccurate. Okay? But it doesn't matter. If you put a stupid word, it tells you 15 case laws. Then you can decide whether they are relevant or not. It throws you out immediately options.
That capability the machine has.
No, we tested it. We said this to the service provider. We'll test it. See, they brought this Article 370 case, and they said we have done I said, you'll be simply clueless. Don't attempt it with anybody else. You will simply fail 9 out of 10 times because you don't know what Article 370 judgment has actually captured. Your AI is impossible of capturing it. But it hastens the process. You can use it as a tool, but you have to train it like a dog for it to behave your way. But still, it can't substitute. A dog can't substitute a child here. Okay, that's the difference. That's the difference between AA and a junior. That's my personal view.
So, before concluding, I'd like to thank, on behalf of this is Lakshmi Narayanan and Senior Advocate N. Venkatraman, and on my personal behalf, the Chennai International Center for hosting us this evening for this panel discussion on the book, and Dr. Vaidya Subramaniam for putting this event together. And I must also thank one of the founder trustees, my beloved Senior Advocate Arvind Pandian, for giving me the freedom and the space as always and being here this evening. Thank you very much for being a patient audience.
Well, I just couldn't resist it. There are a few quotes which I have picked up, which I thought I should share with you. This is already, the eminent panelists have already shared what Mr. K.K. Venugopal has said, but I would like to quote this too. He says, "It is better to live one day as a lion rather than 100 years as a sheep." I would say that age Parasaran has lived nearly 100 years as a lion of the legal profession. I have always had the greatest respect for Sri Parasaran, who is a legal scholar par excellence and an authority on Hindu law. And then he ends with an this is what happens when we flip through. He ends by saying, at the age of 92, when he argued the Rama Janmabhoomi case before the Supreme Court, the Constitution bench asked Sri Parasaran if he would like to sit and argue in deference to his age and stature. Sri Parasaran politely replied that as it was the tradition of the bar to stand and he would like to do so, I can only say that after all that I have narrated and after his long and illustrious career, I wish to tell my good friend Sri Parasaran that he must now take a well-deserved seat in his place among the great lawyers of our time. I think that is a comment which sums up the man and the jurist that he was. One more was by Sri Gurumurthy. Quite a lot has been said, and he says, if I have to describe Parasaran in one sentence, I would say this: he is the man, the bhakta, chosen by Rama himself to argue his case. I pray to Parasaran's Rama that Parasaran should live as long as his Rama himself wishes and keep contributing to this land of Rama and Dharma, which Rama symbolized in Maricha's words, Ramo Vigrahavan Dharmaha. So these, I thought I should quote from the book. The book is available outside, and I would urge you to pick up a copy and go through it in more detail. It's my duty, a pleasant duty, to thank our eminent panelists of today. I thought, they would quote a lot from the verses here, but there were so many takeaways, not only for the young students, but also for many of us who are not so young. I think it's been a learning experience, and each one of us would cherish this even today when we sit back and think about all that they have told us about the man, the legend, and the lessons they had for us to follow in our lives. Thank you very much, sir. Thank you. This has been an honor and pleasure to have this event here, and I thank Sri Vaidya for giving us this, host this at the CIC. Would you like to say some words? It's a free copy, so everyone should pick up a copy on their way out.
Many are wanting online also, if possible, at some point of time. There is a request. Thank you so much for this.
I would like our trustee to say the final words.
On behalf of the trust, I would like to finally thank all the three panelists and Mr. Chandramouli for putting up this event. A few words alone as a professional, co-professional here. They have given the best guidance, particularly what Mr. Envy said with regard to the future of the profession. I think it's an ever-evolving one. So please do not worry so much about what's going to happen. Just enter the profession. It's a jungle anyway. So please don't worry about it. Thank you. And thanks especially for the Honorable Judge for taking away his time also.
Hold